My goal is that everyone can take away a couple actionable steps that you can implement in your business. I know a lot of this sometimes seems like complicated or pie in the sky. So I want to try to get practical and so that everyone can take away a couple actual nuggets that you can start implementing. So the topic of what we're going to discuss is how to avoid lawsuits and even make money with legal, because most people think it's just a cost center, without hiring expensive lawyers. And now, whether I'm expensive or not, I don't know. It's up to interpretation. All right, so lawyers want things to be complicated. Why? Because they bill by the hour. I mean, you can take a look and see some of this. I mean, imagine having a phone call and it costs you $1,500. So that's a little crazy. My view on this is that legal doesn't need to be so complex, especially for small businesses, startups, and entrepreneurs. So now 99.9% of businesses in the US are considered small. So how are you going to afford $1,500 an hour? So maybe if you're Amazon, it makes sense, but then what happens for everyone else? But now, just because it's not, it doesn't need to be as complicated as a lot of lawyers want to make it, doesn't mean that the issues aren't real. So I'll give you a chance to take a look at some of the statistics. And lawsuits are real, and it causes a lot of anxiety. So now, the goal, aside from getting the couple golden nuggets, if you're an experienced or beginner land investor, you'll learn how to efficiently structure your businesses, what to include in your contracts, and how to actually maximize profits through the legal frameworks. Because legal doesn't need to just be a cost center or a suck. I think it can be, but not if it's at the right price. So these low-hanging fruit areas are going to help you avoid legal issues without the unnecessary fluff and the hourly legal bills. So a little about me and how I got started. So my name's Sebastian Garcia. I'm a lawyer, but I'm also an entrepreneur in running this business. And I think that nothing has made me more effective as a lawyer than actually running a business. Because you learn, okay, this is how business owners actually value their costs. This is how they value your time. This is what they care about. Because at the end of the day, you're running a business to make money. So, the bottom line is really important. And if there's a laundry list of things to worry about, there may only be a couple that are actually worth your time and money. So I've worked with over 100 entrepreneurs at this point, a handful of them being land investors, some of you here in the room today. And a little about how I got started. So when I was working at my first job at a law firm, had a little downtime and I was pretty bored. So I started going through the database. I don't know if you're supposed to do that. Don't report me. And I started looking at some of the bills. And I remember one of them was about $50,000 just to file a motion to dismiss. And so what that essentially is if somebody sues you, you have an opportunity to get rid of the case. You would file a motion to dismiss. And I'm like, $50,000? Didn't really make sense. And so that's how I started this business. So the frameworks we're going to go through: asset protection, how to structure your businesses, how to draft your contracts, what are some of the things to include there, and then how to maximize your profits through number 1 and 2. So asset protection, what is it? So asset protection is protecting your hard-earned cash, your stocks, your real estate, your land. I mean, there are tangible and intangible assets. So, an intangible asset is like in your business, you have a lot of operations, intellectual property, and processes that you don't want other people to access. And so protecting your assets also includes protecting them from creditors. So this is people that you owe money to. It's people that want to sue you. It's people that, unfortunately, maybe they get a judgment against you, and you don't want that to go towards your business assets or your personal assets. So now, like I said, I like to break things down in a simple manner and try to think about things in frameworks where there's low-hanging fruit that, if you do the 80% of things that are possible, you get the majority of the results. So I think step number 1 is you want to assess the liability in your business. And this also includes yourself too, because some individuals are very at risk to a lawsuit, especially if you're wealthy, you're high net worth. Doctors are very at risk to lawsuits. Why? Because they're exposing themselves to a lot of liability Lawyers fall into that category as well. It's like high net worth business owners. Step number 2 of what you want to do is you want to actually separate your assets using LLCs. I think a lot of people, and Mike touched on this, they go to start a business and maybe the first thing you want to do is not do the LLC because you want to actually make money first. But you get to a certain point that, you have assets that are at risk. Maybe you run multiple businesses, you own real estate. And then at that point, now is the time to think, okay, I've actually got something to protect. And then that's when it becomes worthwhile. We're also going to talk about what are the best states to set your LLCs up in, because this really matters. Because each state has its own framework of laws, and certain states are going to help you to protect your assets more than others. And then we're also going to talk about asset protection trusts, just as a little bit of a bonus. So asset protection story, how does this stuff actually play out in the real world? Because a lot of it seems very abstract. So there's this concept called the charging order protection, and only 3 states allow for it: Nevada, Delaware, and Wyoming. So that goes back to the whole idea that some states are more important or more beneficial than others. So let's use an example. Let's say your kids are in the backyard, if you have kids, and you have a friend over, and they're playing on the trampoline, and little Sally falls off the trampoline and breaks her arm. So now, what could happen is that family can sue you and try to go after your insurance. Let's say they get a judgment against you and you run multiple businesses. Where are the majority of your assets? They're probably held in your businesses. So what the charging order protection does is it states that if someone gets a judgment against you individually, they can't collect against your assets in the business. And another way that that's important too is that the only way they can get those assets in your business is if you take distributions, or you take income. And so that's very fruitful, especially when you're talking about settling. And you probably want to settle in most cases if it makes sense, especially if you're the business owner. And so because somebody that has a judgment against you knows that they can't just take your money, you don't have to make distributions from your business. So you can sit on your money until the point that they realize, okay, I'm not going to get anything out of this. And that's why the charging order protection is important. And so that's how you would protect yourself if you get sued personally, and how you protect your business. But now, it's kind of unlikely. I mean, I don't know if that's going to happen in your lifetime. It may, like you think about like car accidents, freak accidents happen. But where asset protection becomes really important is in your business. So when you have an LLC or you have a corporation structured, and this is where most of your liability is going to come from actually operating a business. The average person who's just living their day-to-day life probably isn't creating that much liability for themselves, but as a business owner, you are. And what the LLC does is it states that if someone gets a judgment against your business for your business activities, because that's where you're creating liability, they can only take assets from within that business. Your personal assets are protected. And so let's say you run a business, you take a lot of distributions, that becomes your home, that becomes your car, that becomes your savings. So those are your personal assets that you want to keep separate from your business. And so you would do that through LLCs. And over time, the more complex things become, the more complicated your businesses become, the more assets you own. That's when you start to implement different strategies with the LLCs. Let's talk about those strategies. So how do you assess your liability? So remember, it comes down to your personal and also your business. So let's try to make this a little applicable to the land business. So you guys are creating a lot of liability in 2 ways. One of them is in all the purchase agreements that you're doing. So you're sending a lot of those out on a pretty frequent basis. And anytime you have a contract with someone, there's a source of liability there for both you and for the other party. So that's one aspect. And the other aspect is through the marketing channels. And so Sumner touched on that a little bit. There's a lot of laws and regulations when it comes to marketing. And what's a crucial and fundamental aspect of this business? It's producing volume through the mailers. And so a way that you would start to think about my liability and separating your assets is you may have land that you're holding for the long term. That's an asset. You don't want that to be tied into the operations of your business necessarily, because the operations of your business are what's creating the liability. So the marketing, the signing of the purchase agreements. And so what you want to do is you want to take your land. Doesn't have to be every piece of land, because you don't want to have 15 LLCs, because now you have like a administrative nightmare and a bunch of costs. But if you know you have a good piece of land that you want to hold, you may want to consider putting it in a separate LLC. And what you can do is you can have an operational entity. But the way to think about it is, yeah, a lot of things are abstract, but what happens if you actually do get sued and you have to go to court over something like this? Well, if you do go to court, what the court's going to assess is, well, was this actually a business? Is this something that we can protect? Because you have to actually treat your entity like a business for a court to say, okay, yeah, this makes sense. You can only get assets from the business and not from the person. So one way to do that is to have a management agreement or a services agreement. And you can pay that entity, a portion of your funds per month. And so then now that is a separate operating entity that's actually going to be respected by a court. And another way to separate your assets, because the concept is called piercing of the corporate veil. So if a court looks at your entity and they're like, hey, I don't really think this person's actually doing business. They don't have an operating agreement. They don't have a business bank account. Their assets aren't truly separated. A court's not going to respect that entity. So it's important to make sure, and a lot of you already know this, like have an operating agreement, have a business bank account, don't commingle your funds. When you're signing contracts, you're actually signing them with your business, not your individual name. And then a way to get a little more complicated is you can structure the LLC with holding companies and subsidiaries, and it just creates one more layer of protection. So now instead of you individually owning those, the LLC that holds the land, the LLC that is processing the contracts and doing the marketing, it's now a holding company. And so you as the individual are only appearing under the holding company and not the individual LLCs. And I think we can't do a talk on asset protection if we don't talk about trusts. And I think there's a lot of, not necessarily misinformation out there, but a lot of people think that, just a trust in and of itself provides you some sort of benefits with your assets, and that's not true. There are actually a lot of different types of trusts, but we're only going to talk about two. There's a living trust, and there's an irrevocable trust. A living trust is probably what 90-something% of people have and what they need. And what that helps is, and all you know, helps you avoid probate. So if you have a living trust, your family's not going to have to deal with probate, and they're not going to have to go through that very terrible process, as all of you know. But a living trust doesn't provide you asset protection. It's an irrevocable trust that provides asset protection. So when you hear the concept of someone saying like, oh, I own nothing in my personal name, right? Oh, I own nothing. They probably have an irrevocable trust. And there's some pros and cons to that. One of the cons being you no longer control those assets. Now it's a trustee that's actually going to be managing them for you. But the benefit is that that's the most bulletproof way to protect your assets. So now let's talk about contracts, and let's get very specific to the land business. So what to include in your contracts to avoid legal issues and quote unquote stack the deck in your favor. And by stack the deck in your favor, I mean that if a dispute actually arises, you have the tools and you have the ability to make the decisions of how you want to resolve that issue. So the most important sections are the forum selection or dispute resolution clauses. You want to have a precise closing date. You don't want to use option contracts. And so let me explain that in a moment, because I know a lot of you do use option contracts. And another one is conditions precedent. And that would be something that needs to occur in order for the deal to move forward. So forum selection or dispute resolution actually dictates where a dispute is going to take place. So let's say I live in Florida, so that's the example I use. If I live in Florida and I'm buying a piece of land in Nevada, I want to make sure that if I need to sue somebody or a dispute arises under this contract, I don't want to have to go to Nevada in order to process this. I want to be able to have the home court advantage. That's where my connections are. That's where my network is. It's going to be much more of a hassle for me to have to go all the way over there and find an attorney to handle the dispute. You can also have what's called mediation or arbitration. And some states limit though the arbitration specifically as it relates to real estate contracts. But it's basically an alternative dispute forum where you have like attorneys practicing or like retired judges that will oversee it as a panel, and they'll give you a binding judgment. This helps in terms of speed, and it helps in terms of costs. And mediation is basically like it's a negotiation that's just facilitated by a neutral party. And oftentimes it facilitates settlement, which is ultimately what you want. You don't really want to go through a drawn-out lawsuit. You'd probably rather settle, walk away, and at least get some of your costs or get the deal closed maybe at a better price. So now, precise closing dates. So an option contract states that you have the option to exercise your right to purchase that property. But if all you have is an option contract with someone, you can't turn around and say, hey, we're closing in a couple months because we have a purchase agreement. What you actually have is just a right to enter a purchase agreement. So instead of using option contracts, what I recommend is that you use purchase agreements and you just have a closing date that's maybe 2 or 3 months out. Why? Because all of the terms are in there. And another thing too is it doesn't make you have to sign 2 different agreements. You just have your one agreement, and that's what lays the foundation for you to actually be able to enforce it. Conditions precedent are things that need to occur before the transaction actually closes. And so this is important if you're a buyer or a seller. And I'll give an example of this on the next slide. But one other thing I want to talk about before we move on from this one is that all of your contracts need to have an assignment clause, or the ability to get authorization to market the properties. Because what you're doing is you're getting them under contract, and this is specific to y'all in this room. You're getting these deals under contract, and then you're turning around, marketing them, and reselling them. But you need to get the authority from the seller. The reason why is because you don't want to give them the ability to turn around and say, I'm not closing on this deal, and if you try to enforce it, I'm going to say that you misrepresented the transaction, or even that it was fraud. You want to make sure that you get that authority. That way there's no way that they can pull out from the deal, at least on that front. So you need to get in writing the ability to assign the contract and to market the contract. Okay, so let's do a story about the double close, because I know a lot of you do that. If you're buying a deal, the only way that it's going to be fruitful in that scenario is if you have the end buyer and you can do the transaction in a reasonable amount of time. But now what happens if you get into that purchase agreement, you have the end buyer ready to go, and then an issue happens with the end buyer where they don't want to close? Now you're stuck with this deal that maybe you didn't actually want to do, if it meant you needed to hold it for a longer period of time. Maybe it was only valuable to you if you could flip it right away. So that's where something like a condition precedent comes in handy, because now that gives you the ability to walk away from the deal, to say, okay, I'm not going to be able to have to close on this contract if I can't find someone else to buy it. A very common way to think about this is like financing. So when you're buying a piece of real estate, a very typical condition precedent that's almost always going to be in there is that if I can't get bank financing, I don't have to go through with this deal. And that makes a lot of sense. Imagine if I'm going to buy a $500,000 property, but I needed to get a mortgage for it. If I can't get the mortgage, now I have to close. There's no way I'm going to do that unless maybe I get like a hard money loan or something like that. Okay, so with those two things covered, let's talk about how you can actually make money through legal. Because I think a lot of people think, oh, lawyers, they just cost a bunch of money. It's a cost center. I'll just wing it and, cross my fingers and hope that nothing happens. But especially when it comes to closings, if you think about the contract, right? Like, what's something that can happen? Maybe the seller gets squirrely. They get cold feet. They're like, oh, I've had this piece of property in my family forever. I don't want to get rid of it. I decided at the last minute I don't want to go through with this. Well, then what can you do? And that's the whole reason of having contracts in the first place, because, part of what I do is I do litigation and the transactional work. Because if you're just doing contracts or you're just making LLCs, I mean, yeah, it's good in theory, but you're just getting your information from a textbook. It's not until you're actually, letting rubber meet the road, so to speak, that you see how these things play out. And so the way I would go about this is I would send a demand letter, or, to get the terminology of what you can communicate to a seller is you can say, look, you were supposed to close on this date. If you don't close, I'm going to sue you for what's called specific performance. And so that doesn't necessarily mean, although you can, doesn't mean you have to go through a long, drawn-out lawsuit where you try to get damages. Those are the lawsuits that take years, and they're usually worth fighting for years because you're looking to get a lot of money. Otherwise, there's absolutely no point in going through that. At least that's just my philosophy. But specific performance is essentially looking for a judge to say, hey, you had a valid contract and you have an obligation now to go through with this and close. And so that's, specific performance is the terminology that you would use with the sellers in order to get them to close. And then also on that vein of maximizing profits are settling disputes. So if my assets are let's take a step back. Why would someone sue somebody else? It's because they want to make money out of it. That's why in the US we have sort of a litigation machine where there are all these lawsuits taking place because people know, hey, if I sue somebody that's a business owner, if I sue somebody that has a high net worth, I'm able to get a quick settlement and make a little money out of this. It's just the world that we live in. And so if your assets are properly structured, like for example, let's use the example of the charging order. If somebody sues me personally for something that I did, and then they try to collect against my assets, well, what I'm going to tell them is, hey, my businesses are protected. You can't touch those. I don't own anything. I'm actually broke. So then what's going to happen? They're not going to get their money. And so then you're going to be able to settle the lawsuit, or maybe it just goes away entirely. Because you have to think about it this way as well. It's not just a person who's suing you, it's an attorney. And that attorney is only going to take that case if they're going to make money from it. So I'll leave you with that. All right, so how are we doing? Good? All right. I'm going to be the first person today to make you an offer. But the reason why I'm doing it is, obviously, I hope you get all this information and that you're able to use it, take the golden nuggets, and actually implement it right away. And if this isn't for you, you can tune out at this point. But I want to make this offer because I feel like I wouldn't be doing you all a service if I didn't give you an opportunity to actually implement all these frameworks at reasonable cost, because I don't like expensive attorneys either. So this is what you'll get in the offer. I'll assess your assets, your liabilities, and I'll implement the LLC frameworks, if that's applicable. I'll set up your contract library, and I'll overhaul your current contracts that are specifically tailored to your business and your goals. And I'll give you ongoing one-on-one support. So that means meetings, getting questions answered. All the times that you may have felt like, shit, I really want to call an attorney because I have a question, but if I do it, it's going to cost me, I think the number was like $2,000. May not be that much, right? The average is probably around $400 to $500 an hour. Those are the big dogs. But I'll also review all your contracts, provide recommendations, revisions, and insights. All right, so how much money and time will this save you? Well, it depends. It could save you a few $1,000s, maybe in a deal that would have otherwise been lost, or what you would have had to pay to a more expensive attorney. Or it can save you tens of thousands of dollars, maybe in a bigger deal that you wouldn't have been able to close on, or tens of thousands of dollars in needing to defend a lawsuit or settle a lawsuit that you may not have otherwise had to go through. Plus just ongoing cost savings. So what does this typically cost? The implementation of this is worth around $10,000 with the average law firm. Then to keep providing you legal services, a firm may charge $500 per hour plus a retainer. So typically just to work with somebody, they're not going to say, hey, I'll just take, a couple $100 or I'll do a fixed fee. You're going to have to put some skin in the game. Why? Because a lot of these businesses have really high overheads and they're more developed. There's And part of why I started this is because I think there's a huge need. And that's why it's normally so expensive to get this done. So what's it worth to prevent legal headaches? All right, so this is my special offer. So the LIA special offer, $400 per month, and you can cancel at any time. So, 30 days, maybe you decide, hey, I don't really need this. I'll just cancel it. There's no commitment. You're not going to be locked into some long contract. And it locks in 5 hours per month at $80 per hour. So your two choices, you can wait until it's too late and then pay a mega premium. You can wait and overpay for this same service to your local law firm. All right, so this is the special offer. $400 a month, no commitment, it's cancelable at any time. We do the asset protection framework, we make the contract library, provide ongoing guidance and support. The way I like to think about it is, there's a reason why I make it cancelable at any time. If you join and it's just $400 a month, guaranteed you get way more value in that first month than $400. And then you can cancel. And that's the risk that I take. But the idea is that I become a longer-term partner in your business, and that's usually how it plays out and why this offer makes sense for me as well. So how to get it? Just shoot me a text, 201-314-9991. And then for everyone who's even just interested, I'll give you a free call. You'll get value just on that call. We can connect. I've never not had a good experience or not had something come out of it from just getting to meet people and have consultations. So, I think it's kind of ridiculous that attorneys charge for a consultation. I get it, but never hurts to meet people and you never know what happens down the road. So, yeah, that's offered, and I'll talk about how to implement the frameworks, and I'll give you also one-to-one direct advice. So for that 30-minute call, if it goes over, that's fine as well. I'll be able to talk about these things with you, and it'll be specific and tailored to your business, totally for free. But all right, that's enough of my rant, and I hope you guys actually got something from this. And so, let's take some questions.
I got one, Sumner. Yeah, I got it. Good. Could you? Well, I'm a recovering attorney, so. Okay. And I paid my lawyer $900 an hour this year, so it's. Anyways, I was wondering if you could just say a couple of comments. A lot of people in here, when they get to a certain level where this makes sense, and before that it doesn't really make sense. Right. A couple of questions. One, could you speak to the level of someone's assets where it makes sense to go full LLC, corporation owned by trust scenario? Yeah. And then secondly, when someone's thinking about raising outside money, what should they do? Okay.
So first thing on the asset protection side. I think if you own, the way I like to think about it is just multiple businesses where there's like different areas of liability, because like the costs aren't really that high to open the multiple LLCs. You got to pay for the registered agent, you got to pay like the annual report fee. But I think if you own a couple businesses and you have, let's say like I said, like a good piece of land, or you have maybe like an income producing property. Some people say $1 million, like property specifically. You would only put $1 million worth of property in the LLC and then get like a general liability coverage. But my view on it is like things are worth it if they're not charged at $900 an hour. If you had to pay $900 an hour, I would make one LLC and yeah. Yeah, exactly. Yeah. And on the trust side, like I would make a living trust if I just had any assets, just because I wouldn't want my family to go through probate. It's a pretty drawn out process, and it actually ends up costing your family money going through that. So that's when I would make a living trust, if I was just someone who had, maybe like even a home, a couple stock accounts. But an irrevocable trust, I probably wouldn't do that unless I had like $3 to $5 million in assets. It's very complicated. You have like, administrative costs, and that's why I just wanted to touch on it. It's really not applicable for most people. Another thing too is like the estate tax. So when you pass away, I think this year, the number's around 7.5 million, and then it's 14 million if you're married. That might make sense to have an irrevocable trust because your family's going to get, if you have that many assets, everything that goes above those thresholds, you would get hit pretty hard with tax. And so the way the irrevocable trust works is you get those assets out of your taxable estate, and then you don't have to pay the penalties of going above the estate tax. Oh, yeah. 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 So the way I would start to think about raising money is do an exempt Regulation D filing with the SEC. Now, there's a lot of different rules into all those exemptions. I can't remember all of them off the top of my head. There's like the 506B, the 506C. I think the easiest one to do is the 506B. It's Regulation D exemption. It's just a notice filing. So all you have to do is just file the paperwork with the SEC. You don't have to actually get approved or anything, which could be a couple months process. And that's when it's really burdensome to raise capital, because then you have to actually register your securities with the SEC and be approved. So if you don't fit into one of those regulations, you need to register the security. So 506B, it's a private offering. It's an exempt offering. I think it's 35 non-accredited investors. And then you could raise, I think, unlimited from accredited. But yeah, safest way, private offering, close friends and family. You're not running ads for it. And generally you're raising from accredited investors and doing like some reasonable due diligence to make sure they're accredited.
Great talk, Seth. Thanks very much.
Yeah, my pleasure.
Very insightful. Certainly understand the need to have different legal entities for LLCs, different aspects of the business. What are the pros and cons of having the parent entity as a C-Corp? And then part two of that is, what would you recommend as the ideal parent entity holding company to have all of the subsidiaries under?
Yeah. So I think from a liability perspective, LLCs will protect your assets. Corporations will actually protect your assets a little more, because the idea is like, if you have shareholders, and corporations are also subject to double taxation, so it's just automatically much more preferred, because there are those issues, like I said, from a liability perspective. The court is more likely to think that a C Corp is ran as a separate entity. Because some of the times, the problems that people run into with the LLC, a lot of states will have like a general structure that they'll share. So you can get like a group, like let's use an example of like corporate law, for example. Any pro-business state is gonna follow Delaware's corporate laws. And so with real estate, it's very similar. So like, is it a state that's more pro-business, or like let's say like landlord, or pro-business essentially? Because like laws are really always competing. Like, are we pro the consumer or are we pro the business? I would say as like a general rule of thumb, like a lot of the states that y'all are operating in have friendly laws. But yeah, I mean, there are some nuances going from state to state. And like, maybe don't take this as legal advice, but like, a lot of it too is like practice versus textbook, and like everything is about costs, like even for the government. So it's like, how big is a deal that it's worth scrutinizing? It's kind of how I like to think about it.
Seb, we got one more question.
Okay.
Hey, how's it going, man? Mauricio Marin with PRG Land, based here in Nevada. Is there a question for you, or maybe another panelist, but is there anything we need to be mindful of with owner-seller financing notes when we do that? You mentioned the 506B for that one. Is there anything we need to think of for the seller finance notes?
Yeah, so debt is usually treated a little bit differently than it would be if you were actually raising capital. And the whole reason for that is like the SEC uses a definition of like, what is a security? So if something is defined as a security, that's when you fall under the purview of the SEC. A way to think, this is the definition of a security. It's something that appreciates in value without the person having to actually put in their active efforts. So if someone's investing in your deal and it's appreciating because of your work, most likely it's safe to say that's going to be a security. But if it's debt, it's fixed. So they're going to make a certain percentage off of the money.
Seb, he's talking about actually selling a property on owner financing terms. Am I right? Yeah. So
Yeah.
disposing it using a deed of trust or a contract for deed to an end buyer.
To an end buyer.
Do you have any specific concerns around owner financing that you want to know about?
Should I be consistent? Should I stay consistent with the interest rate?
Okay. So we'll talk about the interest rate. But to answer the SEC question, that's the way to think about it. It's debt versus are you selling securities? Is someone buying an interest in my business and they're going to make money because I'm going to work the business? It's like the simplest way to think about it. Like Bitcoin, there's a lot of like speculation. Is it a security? I mean, you see like all the there's a lot of lawsuits around that. And the whole big question there is like, what is defined as a security? But to answer your question on the interest rates, so every state has what's called usury laws. And so there's a maximum interest rate that you can set. Every state is different on that. And if you go above that, technically you could be subject to criminal penalties. Now, I think the way to think about it is like, again, like practice over textbook. If you're giving somebody a note that has a really high interest rate, they're not going to complain, right? But if you're on the other side of that, where they're having to pay the interest, now you can run into an issue because all they have to do is figure out, wait, I was paying 40% when the state's maximum is 15, then you can run into a problem.
I think, Seb, is it typically like 20% across the board, or is it range a ton?
Yeah, it ranges pretty significantly, yeah.
Okay.
Some states have like 8%,
Yeah.
15, I think like highest one I've seen is like 21.
Okay.
So they're, a little bit all over the place.
Okay. Just for context, guys, too, we're going to have a networking session at the end. So I know everyone has questions. It's hard to get to all of them. We are trying to stay on schedule. So Seb will be here. You guys can load him up with questions. Seb, thank you, man. That was awesome. Appreciate that. You killed it, man.